Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to head back out to Illinois now. Now, for as crazy as some states have gotten with their civilian disarmament laws, no state government hates its citizens more than the state of Illinois. We're going to talk about another component of the Protect Illinois Community Act, better known as the Civilian Disarmament Act of 2023, an emergency law which was signed by Governor J.B. Pritzker in a mere 72 hours, immediately banning all assault weapons in the state of Illinois. Well, now one of the more controversial and candidly one of the most unconstitutional components of that law is about to go into effect. So it's going to put a lot of folks in Illinois in a really difficult position, a position that they should never have to be in, a position if there was any intellectual integrity in the Illinois appellate courts, they wouldn't be in this position. But today, we do need to talk about the state forcing its gun owners to incriminate themselves. Okay, so what we're talking about again today is the Protect Illinois Community Act, better known as an innocuous piece of insurance legislation that was transformed into an outright ban of all semi-automatic rifles and several other firearms, signed into law literally in less than 72 hours without any public hearing, without any public comment, and literally went into effect because it had an emergency enactment clause. So the minute Governor Pritzker, and this is important, the minute Governor Pritzker signed that law went into effect, which banned semi-automatic rifles and many other firearms in the state of Illinois. Now, the law does not necessarily require that they go round up all of the pre-existing firearms. No, there is this quasi-grandfather clause, but the grandfather clause requires that Illinois residents register their firearms. That's right, let me say that again. Register their firearms with the state of Illinois no later than January 1st of 2024. We are now into the last 3 months of 2023. And the good news, Illinois, is the state of Illinois has its entire infrastructure all set up. There's an online portal for you to get online and register your firearms. Now, according to the Illinois State Police, their official statement reads as follows. People can now submit an endorsement affidavit online for assault weapons, assault weapon attachments, 50 caliber rifles, and 50 caliber cartridges. On January 10th, 2023, Governor J.B. Pritzker signed into law Public Act 102-1116, the Protect Illinois Communities Act, regulating the sale and distribution of these items in Illinois, along with large capacity ammunition feeding devices. The act went into effect immediately upon signing. Individuals who possessed assault weapons, assault weapon attachments, 50 caliber rifles, and 50 caliber cartridges before the act took effect are required to submit an endorsement affidavit through their firearm owner's identification card account prior to January 1st, 2024. Large capacity ammunition feeding devices are regulated but do not require an endorsement affidavit. As of October 1st, 2023, individuals are able to submit their endorsement affidavits online. Affidavits must be submitted online through an FOID card account. Individuals can access their FOID card account from the ISP Firearms Services Bureau website or going directly to, and then there's this link right there. Now, Illinois, this is the choice that you are being left with. If you want to keep your lawfully owned, lawfully possessed property, you must now register that with your state. And if you fail to do so, you then could have that property taken from you, and you most assuredly would be charged with a crime. Now, what I want everyone to understand is that we can talk about how this violates the Second Amendment on many, many grounds, and that is all true. But what you need to understand, Illinois, is that this also violates your Fifth Amendment grounds on a couple of different grounds, okay? And obviously, the folks in your state legislature have never read the Fifth Amendment. But for all of us who like to geek out and understand that stuff, let us remember that the Fifth Amendment reads, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall have private property be taken for public use without just compensation. And you see, Illinois, what your governor and state legislature has left you with is a choice of, hey, listen, you can register your unlawful items with our state, and thus we can create both an unlawful gun registry, and you can also incriminate yourself in writing. Don't understand how that's unlawful? Well, let us remember that the minute Governor J.B. Pritzker signed that legislation, which was January 10th of 2023, the possession of those firearms became unlawful. Therefore, when you register these firearms, what you are stating to the state of Illinois is that you are in possession of otherwise unlawful contraband. You are literally being forced to provide incriminating evidence against you in violation of the Fifth Amendment. But if you don't do it, what happens then? Well, then they get to come and take your guns and likely charge you with a crime. And that taking is also a violation of your Fifth Amendment. Now, I have geeked out here with the hometown crowd about a case called State v. Flannery. It's a case from Washington State, but it applies equally to what's happening in Illinois. In Washington State, we have a law that if you're charged with a violent felony, you must forfeit your firearms and your concealed pistol license while the matter is pending. Flannery was charged with assault in the second degree. It is a violent felony. He was ordered to forfeit his firearms and CPL. Flannery decided he wasn't going to do that and subsequently was charged with another offense, which was not forfeiting those firearms. When he challenged that indictment, the court in State v. Flannery threw it out because it was a violation of his Fifth Amendment right. How so? Well, you see, when Mr. Flannery made his first appearance in court, and the judge found probable cause to support the charges of assault in the second degree, and then issued his conditions of release, one of those conditions was that he could not possess any firearm or concealed pistol license. That order went into effect the exact moment the judge signed it. No different than how this ban went into effect the very minute that Governor Pritzker signed it. So then, after telling Flannery he cannot possess firearms from that exact moment forward, the order then directs him to go physically possess all of his firearms and turn them into law enforcement. Exactly, in many ways, what the state of Illinois is asking its citizens to do. You can no longer possess these. By the way, we need to file proof under penalty of perjury that you possess these with the location of where you possess them so we can find them. This is in addition to the obvious violations that this has on the Firearm Owners Protection Act of 1986, which clearly prohibits the federal or any state government from using any resource to create a database of firearm owners. Let us also remember that there was a very short period of time around May 4th, May 5th, where an injunction was in place that many FFLs, except for Rod Beavis in Naperville, were able to actually sell semi-automatic rifles for that short period of time. However, Illinois, you need to remember that both your governor and attorney general are stating that you had to possess those firearms before this portion of the Protect Illinois Community Act was enacted, which was January 10th, which means if you have a firearm that falls under the prohibited category that was accumulated in early May, you cannot register that firearm. You have to surrender that firearm. And by the way, if you do register it, you are in fact admitting to a crime. So this is a gigantic mess that no citizen in the state of Illinois should have ever been put through. And like I mentioned at the beginning of this video, had the Illinois appellate courts had any shred of intellectual integrity, of judicial integrity, the folks in Illinois would not be in this position. Illinois, I want to hear from you. What are you all going to do? It's October 1st as I record this video. Registration is now open. You have until midnight on December 31st of this year to register any of those firearms that you previously owned. I am curious to see what you plan on doing. I'm even more curious to see how the state of Illinois handles this. Listen, if you got any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is right down there in the description box. Now, in the meantime, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.